Namaste friends, welcome to my channel. This is your Govindraj. Thank you very much for all your views and also subscriptions and the comments on my previous videos. And this discussion we will talk about salary reduction or pay cut, because these words you are listening because of the COVID-19 effects. The employers are resorting to various options to sustain their business, and of course the employees are also affected. If you are watching this video as an employee, you need to understand that this situation is a very special situation, and both the employer and employee have to cooperate each other to sustain the business and employment. So if your employer is coming up with these measures or option, it is your responsibility to support and cooperate and also sustain your business and employment. So in this case, your salary is not first important. Your employment is important. If the employment and the company is able to sustain, then your salary, benefits, everything will come. So even though I will brief certain legislative provisions for the employer as well as for the employees, so the need of the hour is to both the parties have to cooperate each other and sustain the business and employment. With this brief background, I will proceed with my brief overview of about this topic. So we are going to talk about the legality of pay cut or salary reduction as an option for employers. So if you look at today's scenario, as I told you already, employers and employees have to look into various options to sustain the business as well as employment. So employer has got various options within the purview of the law. One is could be the reduced salaries or salary reduction, which is the point of our discussion today. And of course, you must have heard in the news that there is also a proposal, or the employers are resorting to forced leaves, and also no work, no pay principle is getting talked about it, and the layoff and the retrenchment, and the extreme case is the closure. And also, employers are also looking to reduce or stop the benefits and amenities to reduce the cost on the business. So we have in the previous videos we talked about we briefed about layoff and retrenchment, and we have not talked about other topics. Now let's limit our discussion today on the pay cut or the salary reduction. If you look at all these provisions, they are not very easy to implement also. Even though it is possible within the purview of the law, it comes with certain regulatory or legal restrictions or prohibitions. We need to know and understand before we resort to all these provisions. So as I told you in the previous videos, broadly, Indian employment scenario can be categorized into two categories of employees. One being the employees covered under Section 2S of the ID Act. These people are basically employees who do manual, clerical, skilled, unskilled jobs, and they are not supervisory and managerial staff and management staff. They are not these people. And there is another kind of employees who are basically covered under employment contract or employment order. These are management staff, managerial or supervisory staff. Broadly, you should know that in the employment scenario, these two kinds of categories of employees are available. Why I'm telling you? Because in case of people who are covered under Section 2S of the Act, you need to be aware certain procedure and follow certain regulatory regulations. In case of people who are not covered under Section 2S, it is quite easy and simple for the employer to also to handle, because they are purely governed by employment contract or their employment order. So we will get into this in detail also in the coming slides. As I told you, there are two kinds of employee categories. The salary reduction matter, we need to understand how we can implement these categories also. Now, let's first take up the matter of employees who are covered under ID Act 1947. See, in their case, unilateral reduction of salary amounts to violation of the contract of employment as well as the provisions of the ID Act 1947. And in specific, there is something called Section 9A. As per this section, if the employer is changing any conditions of service which belongs to the workman category under Section 2S, the employer cannot do changes unless he gives a notice of 21 days, or within 21 days of giving such notice, he cannot change any conditions of service. And what are the factors which needs notice under Section 9A? Schedule 4 of the ID Act 1947 lists out these conditions of service which requires a notice. And if you look at this schedule, the subject wage is listed as a first item in Schedule 4. So however, this process is not required if an employer makes any change as per settlement or award. So therefore, employer has this option by giving a notice and waiting up to 21 days. If the employees do not take it up or challenge, then the employer is free to change this condition. Or alternatively, there can be an individual settlement or settlement with the union, and if they agree on these conditions, they can do so. However, it's not so simple as I told you. What happens normally after giving, a notice of change under Section 9A? We should be aware. Normally, what happens? The employee or the workman either challenges or takes up. If there is a union in the company, so the union will take it up with the conciliation, or even they can also raise a dispute before the industrial tribunal. The moment the matter is taken up either through conciliation or as an industrial dispute before the industrial tribunal, then the section 33(1) immediately kicks in. As per this section, if there is any matter is pending before these authorities, the employer is prohibited from changing any conditions of service. So take, for example, in the case of conciliation, if the matter is conciliation, before the conciliation, then if the conciliation is not going to end fruitfully, the conciliation officer will fail the process and then he will submit a failure report. Now it is up to the government to refer it back to the adjudication. So as long as the dispute doesn't get settled down through the process of conciliation and adjudication, employer got stuck. So therefore, if at all the employers are looking to reduce the salaries or wages, it is suggested that it is better discussed with the employees, and also the circumstances have to be told. I'm sure that today's employees are also understand these situations and cooperate with the employees. Therefore, if the employer and employee come together and make an understanding, then without getting into regulatory hassles, it is easy to implement and sustain the business and employment. Now I have talked about situation in the case of employees who are covered under Industrial Dispute Act 1947. Now let's also look into employees who are covered under employment contract. See, in this case, the process is very simple. However, the unilateral reduction of salary amounts to violation of the contract of employment. This is not easy because the employer has agreed that he will pay certain salaries. Therefore, salary reduction can be implemented with the consent of the employees. So what happens if the employer and employee are not able to come to a conclusion or agree on the reduced salaries? In that case, as per the terms of employment, employer will always have the possibility to terminate the services after following the conditions of service as stipulated in the employment letter. So therefore, the employee is also required to understand whether for him the salary is important or the employment is important. In their case, it's very simple that the employer has got all the possibility to terminate after following the conditions of service as per the appointment letter. So employees and employers both have to be careful. No, is it so simple as I have told you? You follow the process of Section 9A and also follow the contract of service. Is it so simple? No, it doesn't come with like that. And there are a lot of challenges or open questions which you need to understand and answer before you implement this process. Let's see those challenges. I've talked about only the notice under Section 9A and procedure in brief. What is the procedure for notice of change? What is the format? What is the condition? To whom to give? So these are all you need to understand. And what are the consequences for employer if the proper process is not followed? And does it violate legal provisions in other legislations like minimum wages and payment of wages? Because if you reduce the salary less than the minimum wages level, does it amount to violation? You need to understand these repercussions. And can employer reduce the basic wages? Because if the basic wages is directly linked to provident fund and gratuity, are you allowed to reduce it? So you need to understand this dynamics and regulations also before you implement. And what is the mode of reduction? Is reduction or deduction? Are you required to revise the rates, or can you go ahead and reduce the salary as a deduction in the monthly salary? Can you do it? Can you implement this method? And are there any provisions under the Indian Contract Act 1872 which impact this process? You need to know before you go ahead and implement. And also let us take another question. Can employer withdraw bonus, ex gratia, and other monetary benefits? Is there a possibility? So I'm leaving you with all these challenges, and find the answer before you proceed with this action. And you keep watching this channel for more updates on this. I may come back on these challenges in the later videos or in the a detailed program on this. And my coordinates are already provided here. You can get in touch with me if you have any clarifications or doubts on this. And as I told you in the previous videos also, my objective is to update these topics to all the professionals and needy people and also employers and managers. Please subscribe this channel and watch this importantly, and share this to as many people as you wish. And finally, don't forget to write your comments, because in the YouTube video you have a comment section. Please write your views, and also if you have any questions, you can also free to bounce back to me. Depending on my timelines, I will definitely come back to you with the answers. Thank you very much, friends. I will leave you with these challenges and questions, and we'll come back to you soon. And see you soon, friends. Thank you very much.